Okay. It's actually a couple of minutes early, but there is a lot of content today, so I'm going to cheat a little bit and get things underway. And Benjamin responded with a thanks with as many S's at the end as there were question marks at the end of this question. So thanks for having a sense of humor. We try to do so as well. So welcome again. My name is Bob Chaput. I'm your host. Will be your presenter today. I'll introduce myself a little bit further in the presentation. I want to thank you for joining us for today's session entitled What Business Associates Need to Know About HIPAA. I used to say what business associates and subcontractors need to know about HIPAA because there was a differentiation in HIPAA land. That is gone. If you are somehow involved in creating, receiving, maintaining, or transmitting protected health information, you are a BA. We'll go through that in more detail. I want to call your attention to the GoToWebinar control panel on your computer screens. Please use it to communicate during the event. We welcome and encourage your questions at any time. In fact, I implore you to ask questions so I can have a break and a sip of coffee. I'd also like to point out and remind you that there's no fee for this webinar. We offer educational sessions to help covered entities and business associates raise their awareness of the requirements under HIPAA and high-tech. We base our curriculum on the exacting language of the laws and regulations and on our proprietary tools, which have been based on those. We've developed these tools over the last 10 years. In this session, we will cover what VAs need to know about HIPAA. At the end of the presentation, I will reference some of the tools and software that we use to help today over 350 organizations become compliant and more secure. I will also mention how you may subscribe to them. While we love to educate, we mention our services for two reasons. One is we have mortgage payments to make and children to feed and college tuition to pay, etc. And inevitably, we're asked for help. So if you, at that portion of the program, you don't want to hear me talk about what we do, that's okay. This is America, and you may check out or exit the room. And when you do, under whatever circumstances you leave and time at which you leave, please do, there's typically a little poll at the end of the webinar when you exit. It'll take like 2 seconds to give us a score and also provide a sentence or two of feedback, and we love that feedback. We are recording today's session, barring any technical glitches or gremlins. We'll post that within 96 hours of the event, at which time we will send you an email with everything, the recorded version and the presentation materials. I will be asked if we will provide the presentation materials, and the answer is absolutely. We will provide the materials. Again, thanks very much for joining us, and let's get things underway. And please, any questions at any time. So here's our topic, what business associates need to know. Maybe you look like that fellow over on the left-hand side if you're a business associate. I'm not sure. The other way we might title this presentation is, why is this man making the other man cry? Because this is absolutely unequivocally a sea change when it comes to HIPAA high-tech compliance for business associates. I'd like to ask you a quick question, and that is, what type of organization are you? If you're attending today, the poll is up. Are you a covered entity, a business associate, someone who does work on behalf of a covered entity, a hybrid organization? You can think about large retail pharmacies, for example, CVS or Rite Aid. These Walgreens, these kinds of outfits have a covered entity portion, and a big part of the business, retail, that's none of the above. So this will help give a feel for who we have attending today. And it's very interesting. I'll show these results in a moment. It's about 50% covered entity, which is really terrific, because even though this session is entitled What Business Associates Need to Know, there is a lot of good stuff that covered entities need to know as well. So without any further ado, let me close this survey out. Let me share the results with you so you have a sense. It's, again, about 50% of covered entities. You might say half hybrid. A small sliver are hybrid. And some of you aren't quite sure whether you're fish or fowl at this point in time, so that's great. Let's go back to the presentation. In case we're meeting for the first time, My name is Bob Chaput. This is my slide that says, I wish I could find a photograph of a, a turnip truck so I could say, I simply want you to know I didn't recently fall off of a turnip truck. I've been involved in protecting very, very sensitive information over the course of my career with some very, very large global corporations, as well as an organization called Healthways, where we maintain the data of about 40 million Americans on 400 terabytes of data. And as a consequence of that, we knew quite a bit about HIPAA. I have a question already. Great. Rick, thank you. How do you know for sure you will be considered a business associate versus, say, a healthcare clearinghouse? Well, you know what? You could indeed have two hats on. If you're a clearinghouse, you are by definition, that's one of the three types of covered entities, you are by definition a covered entity, but depending on who your customers are and the way in which you engage with them, Rick, you may simultaneously be a business associate and entering into business associates with them as well. Hope that helps, and if not, please ask a clarifying question. I have another poll. There are 4 during this event. We have been doing an event called Virtual Boot Camp as well as a live in-person boot camp. We have some coming up. The dates and times are here on this slide. We have a banner, premium quality faculty. I say that humbly. Don't want to say those things with my smiley face on the chart, but I'll point out people like David Finn, former hospital CIO, as now the health IT officer at Symantec. Young Kyung Lee is with the Office for Civil Rights. Jim Piles has been practicing in the area of healthcare, privacy, and security for 40 years. Meredith Phillips is at the Henry Ford Health System as their Chief Information Security Officer and Chief Information Privacy Officer. In any event, if you were to attend such an event, this is just helping us plan this year and next. Just another quick poll. If you were to attend such an event, help us understand for our planning purposes whether you would like to do it from the comfort of your office and not have to travel and put up with that hassle, or whether you would like to attend live and in person. And I'm not going to present all the pros and cons and costs and risks associated with the various alternatives. Some people prefer to get away and be disconnected where they can think for a bit. Others from the comfort of their office, as I say. So it's about 35 seconds into this, and several of you have voted. Thank you very much. Let's close this. And this is kind of an overwhelming 9-1. Prefer to attend in the comfort of their home. Thank you very much. Let's go on. This is legal subject matter. We are not attorneys. I didn't stay in a Holiday Inn Express last evening. We advise all of our clients to consult with inside or outside counsel, whatever the case may be, given the size of your organization, and make sure that you are receiving legal advice. Secondarily, the omnibus has arrived. This presentation is very much omnibusized, including lots and lots of changes, especially focused on changes affecting business associates. And then finally, like most things in the world, you present a question to 5 experts, you're likely to get 7 different responses. Lots of different interpretations. We have a growing amount of cases, settlement agreements, and investigations that are coming out of the Office for Civil Rights, and that's helping guide. The audits are helping to guide. But largely, what's happening is that we're still in the very, very formative stages. That said, if I say anything in this presentation that you find to be out of congruence with your understanding, please let me know. Let's bring it up and let's talk about it, and we'll go from there. Rick has come back and said, regarding a clearinghouse, that is correct reading of 45 CFR 160.103. For those of you who don't know, that is the administrative requirements area of HIPAA and high tech. That to say that clearinghouse is something / functions by passing transactions between 2 covered entities. Oh, is it correct? Is it a correct reading to say a clearinghouse? There's a little bit more to it. It's not only the exchange, but it's the transformation of those transactions, Rick, into a standard format. So remember, In HIPAA land, there are not only covered entities, there are so-called covered transactions. A clearinghouse, typically when you get into the definition of a clearinghouse, you've got to look at what you're doing with those transactions. And if that's not clear, we can talk offline and I can send you some definitional information that people typically use to help size their status, but great question. Just a little bit about a company. We're very excited about what we do. We're helping organizations protect very personal, intimate healthcare information of fellow Americans. We're helping those organizations stay off the wall of shame. There are 4 things that make us very unique and different according to our customers. Number 1, we're not about showing up and when we leave, having left behind dead on arrival PDF reports. We have industry-leading, very unique software that helps you operationalize your compliance programs. We only work with clients who insist on becoming and remaining compliant. I don't mean to sound arrogant about this at all, but if you're looking to check the boxes, we can refer you to many second-tier organizations who will help you with that. Thirdly, we are senior, experienced healthcare executives who have built solutions and services to help others. And as I like to say, oftentimes happens when you deal with big consulting firms, they show up, the partner shows up, there's love in the air, everybody has a burning meeting, and you don't see the partner again until he drives the bus up and lets the kids off to come in and do the work. We don't do that. We show up with seasoned executive people. And then finally, we don't make stuff up. We very, very religiously refer back to follow the rules and regulations and industry-recognized standards. So here's the subject matter today. I'm going to give you the bottom line up front. Before Omnibus, and I should also say before the HITECH Act, Omnibus is just simply a packaging of some regulations to get it through the regulatory process. Really, the driver behind here is the HITECH Act. Before the HITECH Act, when it came to HIPAA enforcement, it was largely reactionary, it was complaint-driven, and if you did some bad thing and you were caught, and somehow there was enforcement, you got a little slap on the wrist in terms of the then civil monetary penalty system. The healthcare industry largely ignored it. Business associates rarely knew or cared, and frankly, business associates would sign anything that a prospective customer would put in front of them. And largely information security was in a bad, bad place. Think about high tech, which really means health information technology for economic and clinical health, part of the stimulus bill. Think of it as, hey, it's time to end your compliance holiday. After Omnibus, we are talking about, use whatever metaphor you want to use, a sea change, perfect storm, game changer. It's big, and the healthcare industry is in huge catch-up mode right now. Make no mistake about it, as it relates to federal privacy and security regulation, it's the largest, most consequential expansion that we have seen. Big time burden on business associates. This is new for BAs. And by the way, by definitional changes, there are significantly more business associates who are now statutorily obligated to comply. And we'll explain something called a chain of trust. And of course, as it relates to enforcement, not only is there much, much more activity coming at you from many more directions, additionally, the penalties that are now codified in the civil monetary penalty system are orders of magnitude larger than what they were before. Our mission today is to help you understand these newly created risks and liabilities as a BA, or if you're a covered entity, understand what your downstreams need to be doing for you and help you mitigate those risks. I mentioned a moment ago, Omnibus is not a thing in and of itself. It happens to be a labeling of a package of regulations that were put together and moved through the regulatory process. If you've not seen this term before, NPRM, Notice of Proposed Rulemaking, that came out in July of 2010, entitled Modifications to HIPAA Privacy, Security, and Enforcement. That was how, as driven by the HITECH Act, there was an interim final rule, that's what IFR stands for, as it relates to enforcement. There was also an interim final rule related to breach notification, and that codified the so-called risk of harm assessment that people were supposed to have completed when they were making a determination as to whether they needed to provide notice. And then finally, the Genetic Information Non-Discrimination Act was also part of that bundling. Lots of people are still waiting for something called the accounting of disclosures requirements. It's not been finalized. We were at the Healthcare Compliance Association meeting this week, asked very directly about that, Leon Rodriguez said, we don't know. It's really a tough one. I don't want to go off target here or off track, but the notice of proposed rulemaking was very, very controversial and received a lot of negative feedback from pretty much all segments of the industry. So the Office for Civil Rights is wrestling with that right now. Our flow today is going to be talking about definitional things, who is and is not a BA. Then we'll talk about how BAs are affected in various areas: security rule changes, privacy rule changes, breach notification, enforcement timing, etc. And then we'll give you some recommended next actions. If you have not heard of it before, or you've been on an interplanetary space mission, the HITECH Act was passed into law as part of the stimulus bill in February of 2009. Section 13401 obligates business associates to comply with the security rule. It also obligates 13404 business associates to comply with provisions of the privacy rule. Just a short note on how this works. The HITECH Act and HIPAA, which is an act, Health Insurance Portability and Accountability Act, are called statutory laws. They're passed by Congress. Oftentimes, lots of times, Congress will hand over to a department in the executive branch of the government responsibility for writing the so-called rules, aka regulations, aka administrative law. So statutory law comes out of Congress, statutes, and administrative law comes out of these executive branch departments. So this is, what you're looking at here, ladies and gentlemen, is the actual HITECH Act, the statutory law. Where do we go from there? Well, among other things, there are some definitional changes. Covered entities are still covered entities, and we had a little sidebar with Rick. There are three basic types: providers, payers, health plans, and healthcare clearinghouses. Business associates used to be defined in a way that if you did work for a covered entity, and in the course of doing that work, you handled protected health information, you used or disclosed it on behalf of the covered entity, you were called a BA. Well, that's been tightened up, and four words that have been circulating around in the world of HIPAA for a long time have been invoked: create, receive, maintain, or transmit PHI. If you do that in the course of your work, you are a business associate. And I'm going to talk about the tiered levels in a moment, but fundamentally, lots of you who may not be sure you're a BA, if indeed you are even storing PHI in physical hard copy records or electronically on disk somewhere, you are, quote-unquote, maintaining it. In the preamble to the so-called omnibus rule, the 563-page tome, the word maintain was actually italicized to emphasize the point that the definition is being broadly expanded. There was a third entity in the land of HIPAA HITECH before omnibus, and that was this idea of an agent or subcontractor. And this created a pecking order or tiers. Covered entities at the top, business associates were direct line to covered entities, and anyone below the BAs were considered subcontractors or possibly agents under the definitions, the common laws related to agency. So what happened, again, before omnibus, there was this definition that in the course of doing work for a covered entity, you handled PHI. Third-party administrators, analytic firms, billing companies, IT, lawyers, accountants, etc. Well, now we go to a definition that explicitly uses these words I mentioned a moment ago, and explicitly calls out other types of organizations like health information organizations. And in the preamble to the omnibus rule, there were questions that were posed as to what does that mean, and give us a definition. And HHS explicitly, purposely chose not to define it because of how rapidly technology is changing in this day and age. So it's health information networks, health information exchanges, regional health information organizations, and on and on and on. E-prescribing gateways are now formally considered BAs. If you transmit and have access to it, so Google, who has been arguing with companies from the beginning of time that they're not a BA, they are, and there'll be a lot of court cases that flesh that out. Microsoft has taken the high road and is now out there turning it from defense into offense and saying, we will sign a BA agreement with you. In the past, physical storage companies like Iron Mountain, as an example, would say, hey, man, we're just storing it. However, as part of this clarification, whether they're storing data or not, they're going to be considered a BA. And everybody downstream from a business associate is now by definition considered a BA. I'll show you a graphic of that in a moment. Also, I want to make a point. There's an exception. It's called the conduit exception. So your internet service provider, your telecommunications carrier, even so that's in the electronic world. In the paper world, FedEx, U.S. Postal Service, UPS, if they're moving PHI around for you, they're not considered a BA. They meet the condition of a definition of a so-called conduit. A covered entity to another healthcare provider is not a BA, and if you were a group health plan that's usually set up by self-insured companies, and let's say GE is self-insured, I know that, and they have a group health plan, that relationship is not considered a BA relationship. Hayes Green asked the question, what about a mobile app? Would they be a BA? Very possibly. It depends on, and it gets into this matter of, and this is where the conduit exception goes. If there is only, that information only exists in a transient state and is just passing through rather than existing for some period of time in a passive state and existing in storage, you may meet the conduit exception, Hayes, or possibly not. So I need a lot of these things are going to be fact specific, and I need a little bit more data about that. Happy to talk to you offline. The bottom line is, ladies and gentlemen, a much wider net has been cast in terms of who is going to be defined as a business associate, and it's millions of organizations. Let's see, Tom said, will you give us some more examples of vendors' businesses that are now BAs that might not realize they are? Your colo data center might have been arguing with you for a period of time that they don't have access to the information. They do. I gave it the example of Google, Microsoft, Amazon Web Services, Rackspace. Cloud vendors are going to be big time more in the crosshairs than they were before. Traditionally, these folks who are listed over here, Tom, on the left-hand side, third-party administrators, analytic companies, etc. Sharon has put in answering services. That's a good one, Sharon. Call answering services. We've always included them on our list. In fact, if you're a covered entity, or for that matter, if you're a BA, hate to have you start here, but I would go to my vendor master file and start working with that, however ominous and big it may be. We've worked with a company that had 8,000 organizations in their vendor master file, and really start asking, first and foremost, do they create, receive, maintain, or transmit PHI? An example of who's not a BA, but with whom you might want to have another agreement, people that come into your office building and do janitorial services or take care of the plants or operate the cafeteria, but maybe wandering around the building. We don't regard them because in the course of their delivering services, they're not responsible for creating, receiving, maintaining, or transmitting PHI. On the other hand, they may have occasional incidental access to it, and we advise that you enter into confidentiality agreements with them. Janice asked the question, are shredding companies business associates? We have been treating them that way for years. My response to that is absolutely unequivocally. They are creating, receiving, maintaining, transmitting, and the handling of that PHI, whether they're shredding paper copies or literally shredding disk drives, hard physical disk drives for you. Privacy rule and security rule. As I mentioned before, Section 13401 and 13404, it used to be privacy and security rule applied only to covered entities, and BAs were hooked into it only by virtue of their so-called BAAs, business associate agreements. Now, BAs have to comply with certain parts of the privacy rule. I'll give you those specifics in a moment, and all of the security rule and certain parts of breach notification. Business associates are now subject to the same civil monetary penalty services, and subject to the same criminal penalties that covered entities have been subject to over the course of the last several years. So remember, no matter where you are in this chain of custody, as what we used to call a subcontractor, you are now a business associate. So more BAs, more risk, more liabilities. And I think what's going to happen, we're certainly advising all of our clients, whether they're covered entities or BAs, to make sure that the folks downstream have their ducks in a row. Here are some business associates. And I'm sorry, David, I just saw your question. What about on-site shredding services? I hear what you're saying, so they may come on site, actually shred it in front of you or drive the truck out back. I'll tell you what, they're handling PHI. I would personally err on the side of treating them as business associates, frankly, so feel free to chime back in. So sometimes I have fun with this chart, and I always have fun with it, but sometimes I have fun by asking the question, what do these folks have in common? There's some pretty prestigious organizations here. Look at KPMG. Those are the guys that did the audits this past year. SAIC, long-standing, decades, reputable, outstanding contractor to the U.S. government. CVS. Where's my friend Rite Aid? Aramark. IBM Global Services. Come on, Iron Mountain. What do they have in common? There are 18 of them here. They're part of the total of 113 business associates who have contributed to the impermissible disclosure of protected health information. So the numbers you see at the bottom are my latest off the Health and Human Services Wall of Shame. 21.7 million fellow Americans have had their information impermissibly disclosed. 12.4 million by these folks and 95 others who have shot their customers in the regulatory foot by impermissibly disclosing this information. Look at IBM Global Services, 1.7 million records. Their customer was HealthNet, an insurance plan in California. They're all over the country, but mostly, I think they're headquartered in California. How'd that happen? 7 hard drives go missing inside of an IBM Global Services data center. Iron Mountain losing tapes. SAIC, this is the movie was 1996. It was called Dumb and Dumber. SAIC, doing work for TRICARE, arguably the single biggest health plan in the United States, taking care of active military and inactive military. A guy who's working at SAIC somehow has the backup tapes in the back seat of his 2003 Honda Civic sitting in a parking garage that was broken into. 4.9 million individuals had their records breached. This is getting to be very serious stuff. You don't want to be, if you're a business associate, in the business of shooting your customer in the foot. If you're a covered entity, you want to make sure these folks have their act together. And that is a huge management responsibility that lots of organizations haven't taken on. Here's the graphic I alluded to. You can put a hospital at the top here. You can put a payer. I just happen to pick a self-insured employer, and they have a group health plan. And the group health plan has a third-party administrator, an outside law firm, an ERP contractor, a wellness vendor, right? And the TPA, let's say, has a portal provider and a data analytics firm. Let's say the data analytics firm uses outside IT. Let's say the IT firm uses, used to be Iron Mountain, now it's Hewlett-Packard, Live Vault Online Data Backup and Recovery Service. Everybody in this chain, especially I'll draw the line here, business associates on down, are now all considered business associates. I should change this chart rather than have subcontractor. It used to be known as that. Every single one of them is now statutorily obligated to comply with the HIPAA security rule, parts of privacy and parts of breach notification. Eileen, if I'm pronouncing your name correctly, has asked, what about OMIG auditors? That's funny. I looked at that. I thought it was OMG, oh my God, auditors. The Office of Medicaid Inspector General. Well, what about them? Oh, is the question, are they business associates? Ah, that's an interesting question. I don't know. But I'm going to find that out. That's a great question. I will tell you this, that Health and Human Services, Office for Civil Rights, and those organizations that are doing audits, and or investigating cases, they're not considered a BA, okay? Oh, yes, they're here. Sorry. I'm sorry to hear about that. I don't think they're going to be considered a business associate, quite frankly. Okay, so know this concept. Regulations create a chain of trust, chain of custody. It doesn't end. For the interested reader, here are some excerpts. This is the HIPAA security rule. If you've not seen this nomenclature before, Title 45, which is around in the Code of Federal Regulations, is around public welfare. Section 164.308, the 300 series is the security rules. So if you see 164.300 series, it's all the security rules. Under administrative safeguards, a very explicit requirement that you, as a government entity, don't hand data to anybody without receiving satisfactory assurances that they're going to safeguard the information. By the way, I'll use this as another example. These rules are literally being redlined. A covered entity is now going to read a covered entity or business associate. We've indeed redlined all these regulations. This will be arriving on your doorstep September 23rd when the enforcement activity is actually in place. Chain of trust doesn't end. By the way, still inside the security rule, 164.308B, what we were just looking at, points to Section 314 and talks about the obligations and what you need to have in your contract. You need to be managing your downstreams. That's the important point of the story here. As a BA, how do we handle our third-party data centers compliance? Third-party organization, Rick, you need to treat them as a business associate. They are statutorily obligated to comply with the 22 standards, 53 implementation specs of the security rule. And if I am reminded to do so, I have a little simple list of 5 questions. I call them 5 starter questions to open the dialogue with all these folks that you should send to them. You ask them about their policies and procedures. You ask them about their training. You ask them if they've done a risk analysis. That will get the dialogue going. But fundamentally, if you are a BA and these folks are downstream from you, third-party data center here in Middle Tennessee, and they're all over the country, Peak 10 is an example. They are statutorily obligated to comply with all these regulations. Here's the privacy rule. This is, by the way, not a newsflash. Privacy rule has said this forever. Contract between a covered entity, easy for me to say, and a BA must do a lot of stuff. Among other things, ensure that the agents, including subcontractors downstream, are paying attention and following the regulations. If you're new to this world and you're wondering what a BA agreement or BA contract may look like, when you receive the slide deck, link to, thank you very much, OCR, link to this particular page and you will see a sample business associate agreement. And this was published on January 25th. At the same time, the omnibus final rule was published in the Federal Register. Let's go into the security rule here. I'm actually going to take a breath and have a sip of coffee. Be right back with you. Thank you. Alrighty then. And please, questions are great. I love what you're doing with the questions, so please asking them. Keep asking them. Okay, before Omnibus, when it came to the HIPAA security rule, by the way, privacy rule, security rule, celebrating their 10th anniversary, send them a card this year and a bouquet of some sort. So privacy rule was effective in 2003. Security rule had a 2-year implementation period. But before Omnibus and high tech, there was no specific guidance that was provided. There was no mandate on any specific technology. It was based on you doing your own self-assessment or risk analysis, and you didn't have, as I mentioned before, any direct liability. Now you have direct liability. You must comply with all 22 standards and 53 of the so-called implementation specs and requirements. And also in the High Tech Act, the Secretary of HHS is now mandated to provide guidance to people, covered entities and BAs. For example, there is guidance out on how to do a risk analysis. There's guidance out on what encryption technologies to use, and there'll be more of that coming. There's going to be guidance coming out. Although this is more privacy related, there's going to be guidance coming out on minimum necessary, among other things. The single biggest priority is risk analysis. As opposed to, for those of you familiar with the payment card industry data security standard, it's very, very prescriptive. I forget the exact number, 122 or 25 very prescriptive things to do with firewalls and policies and intrusion detection and encryption and this and that and the other thing. HIPAA security rule does not do that. It has, by design in the preamble, this notion of flexibility of approach, and it's all based on you doing something that's reasonable and appropriate for your organization. The starting point is to do a risk analysis. There are very rigorous audit protocols out right now, and as I mentioned before, this is now a direct liability for all BAs, no matter where you are in the program. If you want to start thinking broadly about what your compliance program looks like, we call this our compass. And you have to have in writing policies that articulate you're going to become compliant. You care about federal, state, and local laws. You communicate to your people what the behaviors are. That's the what. Procedures come around and provide the how. And so you may have a policy that states we will back up our data every 15 minutes to ensure we never lose more than 15 minutes of it. How's audio going here? Benjamin, you indicated you couldn't hear me. Are we back online? Oh boy. I stopped audio when I had a sip of coffee. That might have been the break, but hopefully I'm back online. Give me a high sign if you would. So policy, procedures, which, thank you very much, which are the what and detail out. Policy on data backup, that's great. Well, how are you going to do it? And how you're going to do it is going to be spelled out in your procedure. People, for me, referencing this as a compass, this is the North Star. The people dimension of your compliance program, whether it's privacy, security, breach notification, Graham-Leach Bliley, payment card industry, is all about three things. Number one, having trained, skilled, smart people on board or outsourced. Number two, having an engaged and supportive executive team. They're part of the audits. And number three, taking your workforce and giving them a break by training them on this stuff so they're not representing to you liabilities. They're in fact assets, if not sentinels. And we've actually worked with organizations, and some of them are here online today, and I won't name names, but Rob, thank you for being here. This is an organization that has built a culture of compliance, and their workforce members are sentinels as it relates to privacy and security. The last dimension of a good compliance program gets to safeguards. And once again, this is not an IT problem. It's not just about some techie thing. There are administrative safeguards, physical safeguards, technical safeguards that you need to implement to control your program. So if you're new to this world, business associates, be thinking broadly about all of these as elements of your compliance program. And in fact, you have to operationalize it. I use this expression over and over again. HIPAA compliance is not a destination. It's a journey. In fact, the words coming out of Health and Human Services are, we're looking for a culture of compliance. Leon Rodriguez, the head of HCR, uses slightly more homey words, and he says, I want the whole enchilada. I want everything on the menu. So as it relates to security, think Deming here, think continuous process improvement or continuous compliance improvement. There's an evaluation requirement inside the rule where you take stock of where you are against those standards. There's a risk analysis requirement inside the rule where you actually go down and deep and look at information assets that create, receive, maintain, and transmit, PHI, look at threats and vulnerabilities, come up with risk ratings, etc. There's a requirement in the security rule for ongoing monitoring, testing, and auditing. And there's a requirement, very explicit requirement, around risk management or risk treatment. There are a couple of questions, one from Elena. I'm curious, what is the industry practice for entities that are BA and CE? Do you have a HIPAA policy? Do they have a HIPAA policy, or do they cover HIPAA in a more general way with a health information policy? Well, you've got some choices there, but one thing for certain, you need to have complete traceability, whether you have a set of privacy policies, security policies, or breach notification policies that are all separate, or you bring them all together in a health information policy. It doesn't matter. It's your choice. But what you need to do, Elena, is crosswalk and be able to crosswalk those back to the to the explicit requirements in the regulation. If we have a moment at the end, I'll show you an example of a crosswalk. Rick asked the question, if you don't have a CISO who owns the, what if you don't have a CISO who owns the compliance process? We think CISOs are wonderful people. We embrace them. We like them a lot. This is a business risk management issue, and oftentimes it sits in the lap of the chief operating officer, general counsel from a legal perspective, or there's a quality officer in the company that drives all dimensions of it, not just the information technology side. David asked the question, if a CE wants breaches to be reported to them rather than the patient, who should your downstream BAs report breaches to? You typically, it's the covered entity's responsibility to do notification, David, unless the covered entity somehow negotiates that with their BA. And we often see that happen with a third-party administrator where they're fundamentally doing a lot of work for a group health plan. But by and large, you want anyone downstream from you to be reporting upstream so that, let's say you're a BA, I don't know what you are, but if you're a BA, you want to have control over that process as it works its way upstream. If you're a covered entity, you absolutely unequivocally want in that chain of custody people not notifying the press, not notifying HHS, not notifying the individuals affected without going through you. So once again, security rule, it's a must for business associates. I'm actually going to skip this poll, and I'm going to skip this poll at this time in the interest of looking at the clock here. I want to go into the privacy rule. So business associates, before Omnibus, there was a requirement that the covered entity establish permitted and required uses and disclosures in the BA agreement, and there were elements such as they've got to, hey BA, I'm a covered entity, I'm saying, hey BA, you've got to limit any further use or disclosure. You've got to implement appropriate and reasonable safeguards. If there's any use or disclosure that's outside of the bounds, you've got to report it up to me. You've got to make sure your downstreams are protecting it. And you've got to ensure, because there are very explicit requirements in the privacy rule around my right as an individual to access it, to amend it, and have an accounting of disclosures, the BAs have to follow those rules as well. And if the BA agreement terminates, God forbid you lose business with a covered entity, you've got to agree to destroy any of that information. So there were very explicit requirements that were spelled out for BAs. Now, it's all of the above, plus if I'm a business associate and I have a breach of our contract, our BA agreement, I must report that, no matter what it is. If I agreed I was going to have policies in place and I don't put them in place, that's a breach. I need to report it to you, covered entity. Obviously, if I have a breach of unsecured PHI, I need to report that. I've also got to comply with the security rule. I've also got to enter into a downstream BA agreement that's compliant with high-tech. And then there's a new provision that says if a BA is largely delegated things that a covered entity would otherwise handle, they must perform against the privacy rule, whatever those requirements are. And once again, I keep going back to a classic example. Group health plan typically outsources a ton of things to their third-party administrator. And that would be like a big GE, a Johnson & Johnson, you name your favorite big company. As opposed to Aetna, Cigna, United, WellPoint, Blues, and things like that, who are payers, their health plans, they've got to do this themselves. But when it gets outsourced to a TPA, that TPA inherits those requirements. Elena asks, are there any tools that you can recommend that help business units to be audit ready? I am asking about tools, not for the audit, but a checklist of guidelines. Yes, there are. I'm going to mention some at the end, Elena. Please hold that thought. So, by the way, whether you're a business associate looking downstream or whether you're a covered entity looking downstream, you've got to get your business associate agreements up to date. There's a little bit of a grace period. If they have not been opened up for renegotiation between March 26th and September 23rd, you actually have until September of 2014. In the privacy rule, business associates are directly liable for these kinds of things. These are the call-outs, as opposed to the security rule where it's one fell swoop. And by the way, there's also a call out. The 400 series inside of Section 164 is breach notification. 500 series is privacy rule. So you're directly liable for the things that are listed here. I'm not going to read to you, but a lot of them are just common sense. The point is you're not, as opposed to the security rule, 22 standards, 53 implementation spec, BAs, you've got to sign up for every single one of them. Privacy rule and breach notification rule is more selective. In the world of breach notification, before Omnibus and HITECH, we had something we called a harm standard, and if you thought you had an impermissible disclosure of unsecured PHI, you had to go through a so-called risk of harm assessment, and that's what's spelled out here. Did you create significant risk of financial, reputational, legal, or other harm to the individual? And as you went through a triage process, you not only performed this standard, there's this concept of, was the PHI secured? So that laptop, the Hospice of North Idaho with 441 individuals on it, that ended up with them being pursued and investigated by OCR and a $50,000 settlement fee. If that laptop had been encrypted, that meets the definition of secured. They had no notification requirements in that case. It's a safe harbor. It's a get out of jail free card or get out of an investigation free card. As it related to the definition of a breach, there were 4 exceptions. They went along the lines of, was it incidental to someone who has, there's no reason to think they're ever going to retain that information and be able to use it. Was it an inadvertent disclosure from one healthcare professional? Dr. Jones picked up the wrong charts, Dr. Smith's. That was one of the exceptions. There was a special exception around limited data sets. If it was a limited data set, it was excluded from being considered a breach. There were 4 exceptions. You'll see that's going to change. There's now the biggest change related to the breach notification rule is that right now, out of the starting gate, as soon as there is an impermissible disclosure, the breach light goes on, and your work is to turn it off. There is a presumption of guilt. Instead of doing a risk of harm assessment, you now must do a so-called risk, or I call it a probability of compromise assessment. You've got to demonstrate that there's low probability that the PHI has been compromised by doing a so-called risk assessment. I hate the fact that they use the phrase risk assessment here because it's confusing with the Benjamin, are you telling me we're having audio problems again? Sorry about that. It's confusing because there's a risk analysis requirement inside the security rule. The burden of proof on a BA is that you have to make sure that you notify upstream, not to the media, not to HHS, not to the individuals. You need to notify upstream. And as I mentioned a moment ago, there are now 3 exceptions instead of 4, and I'm advancing. I expect there are going to be more reportable breaches. Here's what the exceptions were before. The one that goes away is related to a limited data set. I'm not going to spend a lot of time on that because I want to get into enforcement. Before HITECH and before the civil monetary penalty system, there was a set of penalties, or before the new civil monetary penalty system. If that Hospice of North Idaho had that breach involving 441 records, they might have been fined 441 times 100 and up to a maximum of $25,000. So that would have been $44,100 if I'm doing my arithmetic correctly, and it would have been capped at $25,000, thank you very much, for that particular violation. That violation being an impermissible disclosure. But OCR could still come in, even in the old days, and say, well, wait a minute, you didn't implement reasonable and appropriate safeguards. Did you train your people as required in the security rule? No, that's another violation. Thank you very much. $44,000. Whoops, we're going to put the cap on it. That's another $25,000. Did you have a security incident reporting and response system in place? No, you didn't. So there can be a multiplicity of violations related to the loss of that single laptop. That was the case, still is the case. And by the way, a covered entity could put its arm out, stiff arm the government and say, look, we didn't know. We've been undertaking prudent, reasonable care, reasonable diligence. We simply didn't know. And you could actually block a civil monetary. You can't do that anymore. There's a new civil monetary penalty system. The cap compared to this $25,000 is now $1.5 million per violation. Investigations are mandatory. If there's a sense that willful neglect, looks like, smells like willful neglect, utter disregard for the regulations, they must investigate. And by the way, the penalties go back into the coffers of the Office for Civil Rights, and they're going to investigate in further enforcement. There's a provision in the HITECH Act that calls for monies, penalties collected to go back to individuals who are harmed, and HHS was supposed to write a rule around that within 3 years of the HITECH Act passing. They haven't done it yet. They're late, but that's coming. It's going to give people a bigger incentive to go after organizations whom they believe to be out of compliance with HIPAA. I think there's going to be more audits, more penalties, more enforcement coming up. This is a photograph of a very wonderful gentleman. His name is Leon Rodriguez. He's been the director of the Office for Civil Rights since the fall of 2011. He's an attorney by training. He's been a district attorney in Maryland, in Montgomery County. He's been with private law practice. He was with the Department of Justice. He's now the head of the Office for Civil Rights. He's a smiling guy because he's got lots of new enforcement arrows in his quiver. The new civil monetary penalty system, state AGs, have jurisdiction, by the way. That's happened in Connecticut, it's happened in Vermont, it's happened in Minnesota, where they have taken up the cause. They can file civil suits on behalf of their citizens. There are OCR audits underway. 2012 was a pilot program involving 115 organizations. A much wider net's been cast. Breach notification rule, the wall of shame. Separately from Leon, his friends over at CMS are conducting meaningful use audits. And if you are caught in a meaningful use audit, which determines that you've not done a proper risk analysis, you may be subject to a so-called False Claim Act filing. That's what that's all about, and that's pretty serious business. I know I've got some questions. I'm also being sensitive to time, so bear with me. If I don't get to them online, I will answer them separately. Civil monetary penalty system. Whereas in the past you could say, hey man, I didn't know, and I've been doing good work here, and therefore you can't penalize me. You can be doing brilliant work. You can be exhibiting great prudence in how you go about conducting your business and safeguarding this information. Nonetheless, that laptop example indeed looked like willful neglect. I'm not an attorney, but it did look like utter disregard of these regulations. They can actually start with the $100, but they could have multiplied 50,000 times 441. If you are found, that's the best case scenario on this chart. If you are found not to have exercised reasonable diligence, you were not prudent, you were not paying attention, that's called reasonable cause. That's a breakdown or a failure to have serious intent. The opening bid on the 441 records is minimally $1,000. If they find it to be willful neglect, they cannot go lower than $10,000 multiplied by 441, and that corrected means within 30 days. If it's willful neglect, you just thumbed your nose at the whole thing and let it go. Laissez-les bon temps rouiller, let the good times roll. $50,000, that's what they must assign to it. So they have the discretion to use $50,000 at any level. One of the big questions here is, oh, good grief, how are they going to count it? Well, in the preamble to the omnibus final rule, they talked about counting. Counting may be how many days you were in violation. Counting may be, let's say, not only how many days, how many of the regulations or elements of the regulation, those standards I talked about before, you were in violation. Adam Green, who's a great attorney in private practice now, was at OCR. Adam has said, look, there are 22 standards in the HIPAA security rule. If you're out of compliance with all of them, in theory, they could multiply 22 times 1.5, and you could be looking at a $33 million assessment. Ladies and gentlemen, if you have an issue in your organization, act swiftly. of any sort of incident or breach. That's the important message here. By the way, this is not new stuff, but in case you're new to the party, way back in the beginning of time, Congress also established criminal penalties, and depending on the level of severity, it can go up to 10 years in prison and a $250,000 fine. 2 individuals, by the way. And individuals have gone to jail for HIPAA violations. The most recent one, Celebration Hospital in Florida, Dale Monroe. I forget his wife's name. She hasn't been sentenced yet. And a third party, Dale sentenced for a year. Third party, Sergi, sentenced to 4 years. We're waiting to find out about his wife. Okay, let me go on here. In the past, when it came to this enforcement, OCR could conduct an investigation, but they were required to try to resolve it by so-called informal means. Now, if it looks like, smells like, seems to be willful neglect, they not only have to investigate it, but furthermore, they're required to assign to go to the civil monetary penalty system in those cases where it's willful neglect, the third and fourth culpability levels that we looked at a moment ago. If you've not kept track of some of the activity on the part of the Office for Civil Rights, this is a quick summary chart. Hospice of North Idaho, Massachusetts, Eye and Ear, CVS Rite Aid, you know them. Blue Cross Blue Shield, Tennessee, Mass General, Phoenix Cardiac Surgery, 5-doc medical practice. By the way, this is a very, very small organization. Alaska Department of Health and Social Services. Here are the amounts. These are not penalties that are assigned. These are negotiated settlements. There's one case, it's not on this chart, in current times where the civil monetary penalty system has been invoked. This was a plan called Signet. They're located in the, I have a meeting coming up too. They're located in Maryland, and Signet was found. There were 41 individuals with whom they would not, how do I say this? They did not honor individuals' rights to access their own PHI. They were fined $4.3 million, and that is the one case in modern times where OCR invoked the civil monetary penalty system. And by the way, here's a whole, you can go to school on this list, but here's a whole litany of things that people failed to do. These were part of the so-called corrective action plan. It's not just about the federal level. 46 states, U.S. Virgin Island, District of Columbia have all passed their own privacy and or security and or breach notification regulations. This is what the Texas House Bill 300 looks like from a penalty point of view. And yes, if you're in Texas and you are pursued at both the federal and the state level, the money can really start to add up and look like real money. I'm going to pass on this slide. It's just illustrative. I can talk about it, about various ways you can get in trouble related to HIPAA, but I want to talk about timing. The release of the omnibus rule was January 17th, published in the Federal Register on the January 25th, effective date of March 26th, but there's a 180-day implementation period, so effective September 23rd, that's when OCR gets to enforce based on these requirements. What should you be thinking about doing? I don't want to just set you up for, oh my God, we're in trouble. You need to be doing some things, and I'll boil it down to you. First and foremost, you need to set up risk management and oversight in your company if it doesn't exist. If it does exist, have a big new agenda item on it called HIPAA high-tech compliance. That's a requirement in the regulations. The next thing you should do is a requirement in the regulation. Take stock of where you are. Complete a very exhaustive evaluation of where you stand vis-a-vis these regulations. Next, do the exact same thing for the privacy rule and breach notification rule. I said here 22 standards, 53 implementation specs. Privacy rule has, not all of which apply to BAs, privacy rule has 54 standards, 59 implementation specs. Breach notification rule has 4 standards, 9 implementation specs. You need to look at all those and figure out where you stand. You have to do a security risk analysis, whether you're a covered entity or a business associate at any layer in that chain of custody. You need to establish your proactive business associate management program, looking downstream and upstream to make sure you have all your ducks in a row and that you're protected. Someone's not going to get you in trouble. and you need to have a very comprehensive set of privacy, security, policies, and procedures in place. And while you're going through this, not every organization has the resources to take on all 7, so pick one, or if you need help deciding where you need to start, give me a call. I'll point you in the right direction. But while you're doing any of the aforementioned, have a living, breathing remediation plan in place so that you can demonstrate your good faith effort. All of this is by the book, by the regulation. We've had hundreds of clients who have benefited by this playbook, and I commend you and urge you to consider it as you think about the actions you need to undertake. Let's see, Janice said, will I provide a link to number 3 action? Yes, I will. Let me talk about that quickly. What you asked earlier, and this is coming down the home stretch, we have developed 3 industry-leading web-based tools to help people address their compliance and jumpstart their compliance program. One of them is the security assessment. It's located at HIPAAsecurity.com, and when you get the slide deck, this will be a link. This tool examines your compliance vis-a-vis the 22 standards, 53 implementation specs, and asks you 3 audit questions. The tool includes the OCR audit protocol, and it has been totally omnibusized to reflect all the latest and most up-to-date requirements. A companion product, I think this was number 3, Janice, companion product does the exact same analysis, gap assessment for the privacy rule and the breach notification rule, 59 and 54, et cetera, et cetera, et cetera. And then finally, we have a tool to complete a bona fide, by-the-book, according to HHS OCR guidance, which relies in turn on the NIST security framework, a tool to do that risk analysis. Organizations come to us, and we might work with them in one of 3 different ways, and this is where I use a metaphor or an analogy. Some organizations say, okay, great, we've checked out the tools, we've kicked the tires, we like them, we want to subscribe to the software, and we're good to go. We've got skills, knowledge, experience, and time to get the work done. We call that fishing equipment. Some organizations say, we need help. We're pretty good, and we've got people we can assign to it, but we want somebody to make sure we're baiting the hooks properly, netting the fish, filleting them, and whatever all else people do when they fish. And then finally, the fishing charter. This is where organizations say, look, I want an independent, objective third party to come in and just give it to me straight, tell me exactly where I stand, put the remediation plan together for me, and help me get going. The software does the analysis, number 1, produces a remediation plan, number 2, automatically, and number 3, provides an opportunity to actually project manage your remediation plan. Wrapping up, why should you care? It's the law, regulations, many of them, HIPAA and high tech. And more importantly, in my mind, your stakeholders are expecting that you're doing something about this. In fact, they're not only going to be chummy and expecting you're doing something about it, they're going to be auditing you and checking to make sure. And you may be facing pretty significant civil and criminal liabilities and penalties. And probably more importantly, forget all of the above, you might go out of business. We've seen several organizations. One, Lori Swanson, the state attorney general in Minnesota, barred Accretive Health from doing business in that state for 2 years. Their annual revenue run rate there was somewhere between $23 and $25 million, according to their SEC 8K filing. We've seen an organization in California, Impairment Resources. They did workers' comp claim processing, and we had a situation there where someone stole their server on New Year's Eve a couple of years ago, and under the burden of notification costs, legal costs, remediation, forensics, blah, 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 they declared bankruptcy, out of business. So lots of reasons to care. We have a website called About HIPAA, has a lot of resources on it. Please have access to it, avail yourself of that. When you get the slide deck, if you're interested in risk analysis, we have a risk analysis buyer's guide that you can download. And we also have a business associate omnibus readiness check that you can take online yourself. This is a free tool just to help prime the pump and get you thinking about it. We do a lot of webinars, as you know, and that's me. And I am late for a meeting. I apologize. I didn't realize I had booked something so close to this. I know there are some outstanding questions, and I am going to promise you I'm going to go through all of them, and I'll write an email to all of you answering every question. So I want to thank you again very much for being with us today. I know if you're in healthcare, you're super busy. It's been a great session. Your questions have been outstanding, and I promise I will answer all of them. So with that, ladies and gentlemen, that concludes today's live webinar event. Have a great rest of the day and a great weekend. Thanks very much.